Her mugshot has gone viral, and the story behind it is so dark, disgusting, and disturbing. But it is a story that every parent should hear. We are following a story of a babysitter who is accused of the unthinkable. This woman not only allegedly sexually assaulted a child, but prosecutors say she filmed it on her phone. And just wait.
This is the moment a mother's gut feeling cracked open a case so dark that even the detectives in Ocean County say they weren't ready for what they found on that phone. Not a confession, not a tip. A birthday present. And when the birthday girl left it behind, her best friend picked it up, opened Snapchat, and saw something that made her vomit on her own kitchen floor. 5. All arise. The Superior Court of New Jersey, Ocean County, is now in session. The Honorable Judge Patricia Donnelly presiding. Judge Donnelly, mid-50s, wire-rimmed glasses, takes her seat. She opens a thick folder and stares at the first page for a long moment before looking up, be seated. Matter of State versus Victoria Kramer. Counsel, state your appearances. Piraz Kedarmelike. Assistant Prosecutor David Malik for the state, Your Honor. Defense ATRN Wells, Cynthia Wells for Ms. Kramer, who is present at counsel table. Victoria Kramer, 25, sits in an orange jail jumpsuit. Her hair is unwashed, her eyes dart between the judge and the gallery. Her attorney touches her elbow, but she pulls away. This is a pretrial detention hearing. The defendant stands charged with aggravated sexual assault of a child, manufacturing of child sexual abuse material, endangering the welfare of a child, and possession of child sexual abuse material. The state is moving for detention without bail. Proceed. Thank you, Judge. This case begins with an act of kindness. The defendant, Victoria Kramer, was living with a friend.
According to court records, has a daughter who Kramer also babysat for. So Miss P said that Kramer had mental health issues and that for a birthday present for Kramer, she bought her a cell phone. And that cell phone is critical to this case going forward. Now, Kramer's mental health issues, we don't know what the history is related to that. It does not appear that she has a criminal record, but those mental health issues, according to these court records, they were becoming such an issue at home that Miss P told Kramer to get out, but she needed to leave that phone behind. And this is where this story goes to an entirely new and terrible level. Documents alleged that Miss P searches the phone once Kramer left it behind, and she made just the kind of discovery that will never leave you, and just the kind of discovery that would make your heart sink through the floor. Allegedly, she found a 14-second video that was saved on Kramer's Snapchat profile, and it was in the memories section. So that video allegedly shows Kramer sexually abusing a child in the bathroom of the home where she was babysitting. This next part's really sick. Authorities say she was allegedly laughing in that video as she committed the abuse. Now, police say that video was shot all the way back on May 6th.
He pauses. The unexpectedness of the words hangs in the air. A pattern interrupts scene. That phone is now the most damning piece of evidence I have ever submitted in a detention motion. On May 20th, Ms. P asked the defendant to move out. The mental health issues Ms. Kramer was experiencing had become, in Ms. P's words, too disruptive. But when the defendant left, she forgot the phone on the kitchen counter.
Joining us now to talk more about this case is practice professor of law at Temple University and a former sex crimes prosecutor, Marian Bracha. Thanks for being here, as always, on Law and Crime. Really, really disturbing case here. What do you make of the timeline of how long it took to get to the point where there were charges? I mean, this was something that law enforcement, it seems, first learned about back on May 20th.
So I don't think that the timeline is particularly remarkable or really egregious in this case. I think any time an investigative body takes the time it needs to do a thorough investigation, to do what's colloquially referred to as a cell phone dump, to do the forensic analysis they need to do of cell phone contents or video contents and the native files that are attached to the evidence that may be produced from those devices, I think is a good thing. So I don't interpret this lag time, as it were, between the information being provided or allegations having been made and the complaint issued or the warrant issued in this case. I think it likely was the time that the police needed to do their investigation and get the reliable evidence that they needed to substantiate the warrant application.
And now that she's been charged, she's being held, from what we can see, without.
And Ms. P, concerned about what might be on a device she paid for, looked through it. What she found was a 14-second video saved in the defendant's Snapchat account in a folder called Memories.
She found a 14-second video that was saved on Kramer's Snapchat profile, and it was in the Memories section. So that video allegedly shows Kramer sexually abusing a child in the bathroom of the home where she was babysitting. This next part's really sick. Authorities say she was allegedly laughing in that video as she committed the abuse. Now, police say that video was shot all the way back on May.
He takes a breath, and when he speaks again, each word lands like a stone dropped into still water. The video shows the defendant in a bathroom, sexually abusing a young boy she was babysitting, a child between the ages of 4 and 13. And as she commits this act, she is laughing.
Investigators say they later searched the entire phone as well as Cranmer's Snapchat account, and they say they uncovered additional videos in the memories feature of Snapchat. It is unclear at this point what those videos show, but they have been named in court records, which certainly raises some concerns. Now, roughly 2 months after that first video showing Cranmer sexually abused.
A sharp intake of breath from the gallery. Judge Donnelly's pen stops moving. 3 full seconds of silence. Pattern interrupt. Then the judge removes her glasses. Yes, Your Honor. Audibly laughing. The date stamp is May 6th, 2 weeks before the video was discovered. After Ms. P called police, detectives obtained a warrant for a full forensic download of the phone and the defendant's Snapchat account. They found additional videos, multiple, all saved in the same memories folder.
So having video evidence is a very strong evidentiary tool for the prosecutor. Having video evidence is strong for either side, frankly, depending on what the video shows. I think that there are certain evidentiary hurdles that still have to be met when presenting any kind of video evidence or electronically stored evidence or digital evidence. There are still steps that have to be taken to show that the video itself is authentic, that it is what it purports to be, or that there was no doctoring done to it, there was no tampering with the video, or even in this age of AI, that no one created a deep fake, so to speak, that is purporting to show the defendant when this is not a real video or an authentic video. So
a sharp intake of breath from the gallery. Judge Donnelly's pen stops moving. 3 full seconds of silence. Pattern interrupt. Then the judge removes her glasses. We are still analyzing their content, but each file has been named in sealed court records as separate evidence. That raises the terrifying possibility of additional victims. Additional victims. Are you telling me there may be other children on that phone? The investigation is active, Judge. I cannot say more publicly. But I can say that the victim's mother, identified as Miss H, noticed her son's behavior had changed dramatically. He was acting out, withdrawn. She then received a call from Miss P, who had just found the video. That chain of identification is not a coincidence. The defendant was arrested on July 7th. The state's position is that no monetary bail, no ankle monitor, no condition of house arrest can protect the community when the evidence against the defendant is a video she created, saved, and left behind through sheer carelessness. Ms. Wells, your client is 25 years old, facing decades in prison. I will hear your response. But understand me clearly if your argument is that a woman who films herself laughing while abusing a child is not a danger to society. You had better bring me something I haven't already read. The camera holds on Wells as she stands, swallowing hard. Your Honor, we are not minimizing the allegations, but the video has not been independently authenticated by our forensic expert. We live in a time of deep fakes, AI-generated content. It is possible that this video is not what it appears to be.
Is different today than maybe like 5 years ago.
Or 5 months ago.
100%. And I think 5 years ago, if you had told me, any of these, the lowbrow stuff that you see on social media would have blown my mind, where now you can clearly look and say, hey, that's AI, it's moving that quickly. How has the legal system kind of handled that, knowing, we see CSAM cases all the time. How has that hurdle changed? As a prosecutor, how do you prove to a court that this is something where, even for a defense attorney to be able to raise the question of whether or not that's real?
Right. Well, unfortunately, this comes to the point where the courts have to keep up with technology and not the other way around. And so there are movements, there are amendments that are underway in certain jurisdictions to add rules of evidence or to amend existing rules of evidence to envision the use of AI or any kind of generative source that would create evidence to be.
And Miss Cranmer, she has a documented history of severe mental illness. Her father died on Christmas when she was 13. She was taken from her parents at 11, placed in over 30 different homes. She has been in therapy since she was 10. These are not excuses, but they are context. The question today is not guilt, it's flight risk and dangerousness. She has no criminal record. She has community ties. She was trusted by families to babysit their children. For heaven's sake, Ms. Wells, stop. You just told me she was trusted by families, and then one of those families found a video of her sexually assaulting a child in their bathroom. That is not the argument you think it is. Your Honor, the phone belonged to Miss P. It was a gift. Anyone could have placed that file there. We haven't had discovery yet. An independent analysis might show. Are you seriously suggesting that someone else, coincidentally in the same bathroom with the same child, at the same time filmed this act, saved it to your client's Snapchat memories, and then vanished? Is that the defense's position? Dead silence. Kramer's attorney opens her mouth, closes it, then shakes her head. No, Your Honor. I am simply asking the court to consider all possibilities before jailing a young woman with no criminal history and significant mental health needs. Judge, if I may, the forensic report shows the metadata, the account login, the device fingerprint all match one person, the defendant. And beyond that, the state would call Miss P to the stand. Now comes the underdog sympathy beat. Miss P, a woman in her late 30s, rises from the gallery. She walks to the stand slowly, clutching a tissue. Her voice shakes from the first word, Paras Melka. Miss P, you bought the phone. Why, Mrs. P, she was my friend. I'd known her for years. She didn't have any money, and I wanted her to feel like someone cared on her birthday. I gave it to her so she could look for jobs, stay in touch with people. I thought I was helping her. Paras Melka, and what happened when she left your home? I told her she had to leave because her moods were scaring my little girl. She left the phone on the counter. I had this knot in my stomach. I opened it. I went to her Snapchat because I'd seen her use it a lot, and I found the video. I only watched 2 seconds, just long enough to see what it was. I threw up on my kitchen floor. Then I called 911. I called the other mother. I kept saying, I'm sorry. I should have checked sooner. I let this woman near my child. I let her near my child. She breaks down. Judge Donnelly's voice softens, but remains steady. This court does not hold you responsible for the actions of the defendant. You are the reason this case exists. You did what any parent would do. Please step down. Miss P nods, unable to speak, and returns to her seat. Kramer stares at the table, avoiding her eyes. The prosecutor rises for his final point. Judge, the evidence of danger is not just the video, it's the laughter. The deliberate saving to a folder called memories, as if this were something to look back on fondly. And the unknown content of the additional videos. The state asks for pretrial detention. If she is released, I have no confidence she will appear, and I have no confidence she won't reoffend. Your Honor, we ask for house arrest with electronic monitoring or a substantial bail with conditions. Miss Kramer is not a flight risk. She has no passport, no financial means. And as for danger, mental health treatment could address the root causes of these alleged actions. Prison will not. The judge leans forward, removing her glasses. She addresses Kramer directly. Miss Kramer, I have been on this bench for 18 years. I have viewed a still frame from the video the state submitted. I have read the probable cause affidavit. I am going to rule based on what I know now. This is a pretrial detention hearing, not a trial. But I cannot, in good conscience, imagine any set of conditions that would protect the public from someone who would commit such an act, film it, save it in a folder labeled memories, and then leave that evidence in the hands of the very friend who trusted her. The defendant is ordered detained without bail. The court finds by clear and convincing evidence that no conditions of release would reasonably assure the safety of the community. We are adjourned. Gavel. The sound echoes. Kramer stares ahead, blank-faced. As court officers lead her away, the camera holds on her just long enough to catch a flicker of disbelief, not remorse, but shock that her own saved memory is what undid her cut to host Chris Stewart at the anchor desk, Kramer's mugshot filling the screen behind him.
There are rules of evidence that also protect the defendant from engaging, from having the evidence of her engagement in plea negotiations admitted against her. So it's not like she would engage in conversations with the prosecutor and say, I'm willing to plead guilty to this charge, but not that charge. And then all of a sudden a fact finder would hear that she had been willing to plead guilty to a particular charge. So she is protected from admission, from the admissibility of the fact that she was willing to engage in the negotiation to begin with. So I don't think it matters too much from a strength of negotiation perspective. I think there is always the priority of protecting the victim from further trauma and further exploitation. And I think there is always the concern about system utilization and judicial economy, and is the right and the just result to have this case tried before a jury and to have this video played in open court, or is the right and just thing to do to dispose of this with a non-trial disposition? And that's something that both sides would have to engage in.
That was July 7th. Victoria Cranmer is still in the Ocean County Jail, held without bail. But since that hearing, we've learned two things that change everything. First, the forensic analysis is complete. The Ocean County Prosecutor's Office confirms that the phone contained multiple videos, plural, all saved in the Snapchat memories folder. They haven't described what's in them, but they have named each file in sealed court documents, which means each one is being treated as a separate piece of evidence. That strongly suggests additional charges are coming. And second, Miss P's daughter, the child Cranmer also babysat, has not been publicly cleared. Investigators haven't said she's safe. They haven't said she's a victim. That silence is deafening. He leans forward, voice dropping. We are also watching for a very specific motion that the defense is expected to file within the next 2 weeks, a motion for a competency evaluation. Cranmer's childhood trauma, her mental health history, it will all be dragged into open court. The judge finds her incompetent to stand trial. She won't walk free. She'll be committed to a state psychiatric facility, potentially delaying justice for months or years.
Former sex crimes prosecutor, practice professor of law at Temple University. Always great to have you here at Law and Crime. Thanks for being with us.
Thank you so much, Chris. Nice to see you.
Again, online court records do not show the next date when Cranmer is expected to be in court, but we're going to continue to follow this story. We will keep you posted if more charges are filed or more information comes to light. That will do it for On the Case, presented by Law and Crime. Subscribe to us on YouTube and Spotify, and we're also streaming on Peacock. I'm Chris Stewart. We'll see you next time.